My sister invited me to her mansion the night before our federal court hearing. That alone should have told me it wasn't about dinner. Her house sits on the north side of Atlanta, behind iron gates and trimmed hedges that look like they're inspected by a committee. I pulled up in my 10-year-old Toyota with a dent in the rear bumper and parked next to her husband's brand-new imported SUV. The contrast was almost funny. Almost. The front door opened before I knocked. Victoria. Everyone calls her Tori. Now stood there in a fitted cream blazer that probably cost more than my monthly rent. Her smile was tight. "You actually wore that?" Her eyes moved from my boots to the sleeves of my Army service uniform. Yes. She stepped aside and let me in. The foyer smelled like expensive candles and polished wood. Everything inside looked staged for a magazine shoot. Glass table, marble floors, no fingerprints anywhere. I hadn't changed into civilian clothes. I had come straight from Fort Liberty after a long drive. My uniform was clean and pressed, but it wasn't new. The cuffs were slightly worn. Years of ceremonies, briefings, and travel do that. Fabric doesn't last forever. Tori walked me into the dining room. Daniel was already there, leaning back in his chair with a glass of scotch. He's a corporate litigation attorney. He wears confidence like it's tailored. They both looked at my sleeves again. Tori laughed first. "You look like a tired security guard," she said, shaking her head. "And you're planning to wear that into federal court tomorrow?" Daniel smirked. "Presentation matters." I sat down without reacting. The table was long enough that we could have hosted a small conference. Instead, it was just the three of us and a single folder placed in front of Tori. Dinner arrived from a private chef I never saw. Something with rosemary and red wine sauce. I focused on the plate. Tori didn't. "You really think that judge is going to take you seriously looking like that?" she continued. "This isn't a base legal office. It's federal court." She said federal court like it was a country club she belonged to. I took a sip of water. "The judge will look at the documents." Daniel let out a short laugh. "The judge will look at credibility." Tori slid the folder across the glass table toward me. It stopped just short of my plate. "Open it." Inside was a cashier's check, $75,000. For what I asked. For being reasonable, she replied. "Sign the waiver. Step down as executor. Let me handle the land. You take the money and go back to North Carolina." Daniel leaned forward. "It's more than generous. You don't even own property right now." That part was true. "I rent. My job moves me around. I don't invest in luxury real estate. I invest in stability." "The land isn't for sale," I said. Tori's jaw tightened. "It's 200 acres of undeveloped forest. Dad didn't even maintain it properly the last few years. Magnolia Resorts is offering real money. Jobs. Revenue. Growth." "Dad put a conservation easement on it," I said. "He signed it. Filed it. You know that." She waved her hand. "Easements get challenged all the time." Daniel tapped the table lightly. "The easement is tied to a federal tax credit. That's the only reason we're in federal court. If we remove you as executor, we can revisit the validity of that filing." There it was. Not just a disagreement, a strategy. "You think I'm the weak link," I said. "We think you're inexperienced," Tori replied. "You've been in the Army your entire adult life. Logistics, civil affairs deployments, that's not estate management." I didn't correct her about my branch or my responsibilities. It wasn't necessary. "You live in a rental apartment," she added. "You drive that car. You don't have a portfolio. Tomorrow, in front of a federal judge, they're going to ask why you should control a multi-million-dollar asset." Daniel nodded. "And we're going to answer that question for them." I looked at the check again. $75,000. A clean exit. "You're trying to buy Dad's wishes," I said. "I'm trying to fix a mistake," Tori shot back. He was emotional at the end. He didn't understand the market. He understood exactly what he signed. Her voice sharpened. "You think this is about trees? It's about responsibility, about maximizing value. It's about honoring a document," I said. Silence settled for a moment, not dramatic, just quiet. Tori pushed the check closer. "Last chance. Sign the waiver tonight. We avoid tomorrow's embarrassment." "Whose embarrassment?" I asked. She looked directly at my sleeves again. "Ours." Daniel leaned back. "Federal judges don't salute uniforms. They analyze competence." I held his gaze. "Good." Tori laughed again, louder this time. You really believe that? You walk in there in that worn-out suit, and you think anyone sees leadership? I looked down at my uniform. The Bronze Star ribbon was aligned correctly. The Combat Action Badge sat above the ribbons exactly where it belonged. The cuffs were worn, not dirty. I'm not dressing for them, I said. For who, then, she asked. For myself. She rolled her eyes. You always do this. You go quiet and act like that's strength. It works. Daniel cleared his throat. Let's be realistic. Tomorrow we're asking the court to remove you as executor. We have financial comparisons, income disparities, asset management experience. You have a government salary and deployment history. That's enough, I said, for what Tori demanded. To know I'm not signing that. She stared at me for a long second. You're making this harder than it needs to be. No, I replied. I'm making it exactly what it is. Her expression shifted from mockery to frustration. You're going to regret walking into that courtroom like this. I closed the folder and pushed it back toward her. I'll see you in the morning. Daniel shook his head. You're walking into a federal hearing underdressed and unprepared. I'll be prepared, I said. Tori stood up. Fine, but don't expect us to protect you when this backfires. I rose from the table. I'm not asking you to. She glanced once more at my sleeves. You could at least buy a new suit. I adjusted the cuff lightly. This one still fits. I walked out through the same marble hallway, past the polished staircase, and framed awards from her real estate firm. Outside, the air was cooler. My car looked even older under her driveway lights. I got in, started the engine, and let it idle for a moment. Tomorrow wasn't about fabric. It wasn't about presentation. It was about a document filed years ago, a signature placed carefully at the bottom of a conservation easement, and a federal court that would decide whether that signature meant anything. Behind me inside the mansion, they were probably finishing dessert and planning how to dismantle me in the morning. I shifted the car into reverse and drove out through the iron gates without looking back. The highway lights blurred past my windshield as I drove north, the mansion shrinking behind me in the rearview mirror. Traffic thinned out once I left the city. Atlanta at night can feel loud even when it's quiet. Billboards, headlights, noise that doesn't stop. By the time I crossed into the darker stretch of interstate toward the mountains, it felt like I could finally think without someone evaluating my sleeves. The land sits about 90 minutes outside the city, past the last chain grocery store and a handful of gas stations that close early. 200 acres of mixed hardwood forest rolling hills and a narrow creek that runs along the eastern edge. No gate, no security camera. Just an old gravel entrance and a wooden sign with our family name carved into it. Callahan property. Dad carved that sign himself after he retired from the Marines. He said if he was going to own land, he wanted to touch it first. I turned onto the gravel road and let the tires crunch slowly forward. The trees closed in overhead. Even at night, you can tell the difference between a developed property and one that's been left alone. No light pollution, no paved driveways, just quiet. I parked near the old shed and stepped out. The air smelled like damp soil and pine. Nothing manicured, nothing staged. Tori calls it underutilized. I call it intact. The conservation easement wasn't some last-minute emotional decision. Dad had been talking about it for years. After his second heart scare, he started meeting with a land trust organization out of North Georgia. They walked the property, documented wildlife, surveyed boundaries, filed everything properly. The easement restricted development permanently. No subdivision, no resort, no commercial construction. It qualified for a federal tax deduction under IRS Section 172. That deduction is the reason this case landed in federal court instead of staying in probate. Dad signed the easement 3 years before he died. It wasn't rushed. It wasn't hidden. Tori knew about it. She just assumed she could outmaneuver it later. I walked down toward the creek with a flashlight. The ground was uneven, but I knew the path. I used to spend summers here before ROTC, before deployments, before the Army turned my schedule into a series of departure dates. Dad used to say the land was the only thing in his life that didn't require rank or permission. He didn't have to report to anyone out here. I sat on a fallen log near the water and pulled out my phone. I opened the email thread I had printed earlier that week. Subject line: Magnolia Resorts. Preliminary Development Proposal. It was addressed to Tori. Attached were projected revenue numbers, design mock-ups, and a draft letter of intent. The date stamp was 6 weeks before Dad passed. She had already started negotiating. In one message, she wrote, "Once the estate is settled, we'll clear the easement issue." Clear the easement issue, like it was brush in the way of a driveway. I wasn't surprised she wanted to develop it. That's what she does. She looks at land and sees vertical growth, investors, market timing, appreciation curves. Dad looked at it and saw quiet. When he told us he was naming me executor, Tori didn't argue in front of him. She waited until we were alone in the kitchen. Why her, she asked him. He didn't hesitate. Because she won't sell it. At the time, I thought that was enough explanation. Apparently, it wasn't. The executor role isn't glamorous. It's paperwork. Court filings, inventory of assets, making sure debts are paid, and directives are followed. It's not about profit. It's about compliance. Tori sees compliance as a starting point for negotiation. I walked back toward the shed and leaned against the wooden wall. The flashlight beam caught the edge of the easement marker posted near the boundary line. A small metal sign indicating protected land. Magnolia Resorts would have bulldozed this entire stretch first. It's the flattest area. The federal element complicated everything. Because Dad claimed a conservation tax deduction when he filed the easement, the IRS had jurisdiction over the legitimacy of that filing. Challenging the easement meant challenging a federal tax matter. That's why Daniel filed in U.S. District Court for the Northern District of Georgia. He wasn't just attacking my role as executor, he was trying to reopen the validity of a federal filing. If the court ruled the easement defective, it could trigger tax penalties against the estate. It could reclassify the land as unrestricted. It would open the door to development. Removing me as executor was step one. Without me, Tori could petition to renegotiate the land trust agreement. I checked my phone again. A message from my unit's security manager sat unread. Reminder: disclose ongoing federal litigation in clearance file. I had already reported it earlier that week. Army officers with active security clearances are required to disclose significant civil litigation. It doesn't mean you're guilty of anything. It just means the government wants transparency. Still, it's not ideal. If Daniel succeeded in framing me as financially incompetent in federal court, that narrative wouldn't disappear when I put the uniform back on. Tori had built her strategy carefully. She knew my career required credibility. She knew public questioning of my judgment could ripple outward. I turned off the flashlight and stood in the dark for a minute. No traffic noise, no legal arguments, just wind moving through trees. When Dad filed the easement paperwork, he brought me the draft before signing it. "Read it," he said. I did. Every line. Legal descriptions, boundary maps, restrictions, duration perpetual. "You understand what this means?" he asked. "It means no one can touch it," I answered. "That's the point." He wasn't naive. He knew the land was valuable. He knew Tori's industry. He wasn't against development in general. He was against turning this specific place into a revenue stream. He told me something else that day. "If this ever becomes a fight," he said, "don't argue with emotion, argue with paperwork." I looked around at the trees, then back at the shed. Paperwork was exactly what we had. Tori wasn't wrong about one thing. Federal court isn't impressed by sentiment. Judges look at filings, compliance, and precedent. The easement had been reviewed by a certified appraiser, approved by a 501c3 land trust, and recorded with the county. The IRS deduction was processed without issue. There was nothing sloppy about it. The attack wasn't on the document, it was on me. Daniel's motion to remove me as executor cited lack of financial sophistication and limited asset management experience. He attached my military income statements as comparison against Tori's corporate earnings. Income disparity as a legal argument. I walked back to my car and sat behind the wheel without starting it. The dashboard clock read 11:42 p.m. Tomorrow they would stand in a federal courtroom and present me as underqualified. They would point to my rented apartment and my government salary. They would use the word competence like it belonged exclusively to boardrooms. I rested my hands on the steering wheel and looked through the windshield at the dark outline of the trees. Dad didn't choose me because I was richer. He chose me because I follow instructions, and the instructions were clear. I started the engine and let the headlights cut through the gravel road, guiding me back toward the highway. The gravel faded into pavement as I merged back onto the highway, the headlights stretching in a straight line toward Atlanta. By the time I reached my hotel near the federal courthouse, it was after midnight. Nothing fancy. Clean bed. Neutral carpet. The kind of place where no one asks questions if you're in uniform. I laid the court binder out on the desk and opened it again. Daniel's motion to remove me as executor was neatly structured. Confident. Professional. He framed it as a matter of fiduciary responsibility, not sibling rivalry. That was deliberate. He argued three things. First, that I lacked sufficient financial experience to manage a multi-million-dollar estate. Second, that my full-time military obligations created a conflict with executor duties. Third, that maintaining the conservation easement without re-evaluation could materially diminish asset potential. Asset potential. That phrase appeared 6 times in the filing. He attached financial exhibits comparing my annual Army pay to Tory's corporate earnings. He included market projections from Magnolia Resorts showing projected revenue over 10 years if the land were developed. On paper, it looked persuasive. What he did not mention was that an executor's job is not to maximize profit. It is to execute the will as written. I turned to the copy of the easement agreement. Signed, notarized, recorded. The land trust's acceptance letter was attached. IRS form 8283 was properly filed at the time the deduction was claimed. The appraisal met federal standards. The easement was valid, so the strategy shifted. If they couldn't attack the document directly, they would attack the person enforcing it. I closed the binder and checked my phone again. A secure email from my unit's security office confirmed my litigation disclosure had been received and logged. No further action required at this time. Those last 4 words mattered. No further action. Still, federal court is not something most Army officers casually add to their week. Civil affairs officers work with local governments, community leaders, infrastructure projects. We operate in environments where documentation and compliance are critical. That part of my job aligned cleanly with executor duties. But Daniel wasn't going to argue nuance. He was going to argue optics. The next morning, I walked across the street to the courthouse to familiarize myself with the building layout. U.S. District Court for the Northern District of Georgia sits in a granite structure that looks exactly like what you imagine when someone says federal. Wide steps, tall columns, security checkpoint inside. I cleared security without issue. Active duty ID simplifies things. The officer at the metal detector glanced at my uniform and waved me through. Inside, everything was orderly. Courtroom assignments posted on a digital screen. Our hearing was scheduled in courtroom 4B at 9 a.m. I located the room and stepped inside. Empty benches, counsel tables. The judge's bench elevated but not theatrical. This wasn't a movie set, it was a workplace. I sat briefly at the defendant's table. Tomorrow, Daniel would sit across from me, likely with an associate or two. Tory would be behind him, observing, evaluating. The hearing was procedural. Daniel was asking the court to remove me as executor and to authorize review of the conservation easement under federal tax implications. If he succeeded in the first request, the second would become easier. Executor removal requires proof of mismanagement, conflict of interest, or incapacity. There was no mismanagement. All estate filings were current. Debts paid. Asset inventory complete. So the argument rested on capacity. Capacity can be subjective. After leaving the courtroom, I stepped outside and called Colonel Harris, my brigade commander. He had been briefed on the litigation when I disclosed it earlier that week. "You good?" he asked. "I'm good. You expect this to affect duty performance?" "No." "Then treat it like any other administrative issue. Facts win. Facts win. Simple." He didn't ask what I was wearing. He didn't advise me to soften anything. In the Army, your record speaks. It's documented, structured, verifiable. Civilian courtrooms work the same way, even if the presentation style differs. I returned to the hotel and reviewed Daniel's supplemental memorandum. He cited case law regarding fiduciary competence. In one precedent, an executor was removed due to failure to properly manage investments. In another, removal occurred because of prolonged absence from the jurisdiction. He subtly implied that my deployments demonstrated a pattern of absence. My Afghanistan deployment ended in 2015. I had been stateside for years. He knew that, but the suggestion alone could plant doubt. I drafted a response outline for my counsel. I wasn't representing myself entirely. Estate matters require formal counsel of record. My attorney, Ms. Parker, was experienced in probate and federal procedural overlap. She had already prepared counter-arguments emphasizing that executor removal cannot be based solely on income level or career path. Still, I wanted my own notes, not emotional arguments, structural ones. Executor duties completed to date. No breach of fiduciary obligation. No delay in asset distribution. No personal benefit taken. Compliance with land trust requirements. IRS documentation intact. I paused and looked at the uniform jacket hanging on the back of the chair. Tori had called it worn out. Technically, it was older. I'd worn it to promotions, memorial services, official briefings. Fabric doesn't stay crisp forever, but it was regulation compliant, clean, proper. Daniel had made a comment the night before that stayed with me. Federal judges don't salute uniforms. He was right about one thing: judges don't rule based on fabric. They rule on filings. The easement filing was solid. The executor documentation was clean. The financial comparison argument might appeal to emotion, but it didn't override statutory obligations. I checked the docket one more time online. No new filings. No emergency motions. Hearing time confirmed. Downstairs in the hotel lobby, a small television was running a news segment about commercial development in North Georgia. I caught the word resort and muted it in my head. Magnolia Resorts had political connections. They had investors waiting. That pressure wasn't in the courtroom record, but it existed. Tori wasn't just fighting for profit. She was protecting a deal already in motion. If the court removed me, she could move quickly. I went back upstairs, set an alarm for 6 a.m., and placed the binder neatly beside my bag. There was nothing left to prepare beyond what was already documented. No last-minute maneuver, no surprise filing, just a federal hearing scheduled for the morning where competence would be measured against compliance and income charts would be weighed against a signed easement. I turned off the lights and let the room settle into quiet. Tomorrow would not be about who spoke louder. It would be about whose paperwork held. The hotel alarm went off at 6 a.m., but I was already awake, staring at the ceiling and thinking about a kitchen table from 20 years ago. Back then, our house in Savannah was smaller. One story. Yellow siding. Dad kept his Marine Corps photo in the hallway next to the thermostat. Tori kept her academic trophies on the living room shelf. She was always ahead. Student council president, debate team, internship by sophomore year of college. When she talked about business, adults leaned in. When I talked about ROTC, they nodded politely and asked if I had a backup plan. At family gatherings, relatives asked Tori about internships in Atlanta. They asked me if the Army was dangerous, like it was a hobby I picked up without thinking. Dad never treated it that way. He didn't overpraise me either. He just asked practical questions. Where are you stationed next? What's your chain of command look like? You squared away. Tori once joked at Thanksgiving that I joined the Army because I didn't like interviews. You don't have to impress a hiring committee, she said. They just issue you a uniform. I remember answering without looking up from my plate. You still have to qualify, she laughed. Everyone else did too. It wasn't cruel. Not exactly. It was the kind of comment that sounds harmless until it repeats for years. By the time I commissioned as a second lieutenant, Tori was already climbing the ladder at her real estate firm. She didn't come to my ceremony. She had a client meeting. She sent flowers instead. The card said, "Proud of you. Stay safe." Dad came. He stood in the back of the auditorium in a pressed shirt and watched them pin the bars on my shoulders. He didn't clap loudly. He just nodded once. After the ceremony, he shook my hand instead of hugging me. "Now you answer to something bigger," he said. Tori answers to markets. I answer to orders. The difference shaped everything. When Dad bought the land in North Georgia, Tori treated it like a future development site. She asked about zoning restrictions before she asked about trees. I asked about water access and boundary lines. She'd walk the property and talk about cabins. I'd walk it and talk about maintenance. The conservation easement conversation didn't start as a fight. It started as a disagreement over philosophy. Dad called us both to the dining room table one afternoon, years before his death. He laid out a folder with documents from the land trust. "This locks it in," he said. Tori skimmed the first page and frowned. "Permanently?" "Yes, that's irresponsible. It's intentional," he replied. She looked at me. "You agree with this?" "Yes, of course you do," she muttered. The argument didn't escalate that day. Dad was firm. Tori didn't push further in front of him. But she didn't accept it either. After his second heart scare, when doctors started using words like lifestyle adjustments, Tori's tone changed. "You need to think about estate liquidity," she told him. 200 acres tied up in forest isn't strategic. Dad leaned back in his chair. "Not everything has to be strategic." When he named me executor, he didn't frame it as a competition. "It's administrative," he said. "You're structured." That word bothered Tori more than any other. Structured. She built her identity on being dynamic, adaptable, aggressive in negotiation. Structured sounded small to her, but in the Army, structured keeps people alive. It keeps operations within parameters. It keeps documentation clean. She once told me I was too quiet to lead. "You don't push back," she said. "You just sit there." "I don't react to everything," I replied. She shook her head. "That's not leadership. That's avoidance." In her world, leadership meant dominating a room. In mine, it meant controlling variables. The tension never exploded. It layered. At Christmas dinners, she'd update everyone on acquisitions and closings. I'd update them on assignments and training exercises. Her stories came with numbers and headlines. Mine came with acronyms most of them didn't understand. Daniel entered the picture during one of those Christmases. Sharp suit, confident handshake. He asked about my branch like it was a trivia question. "So what exactly does civil affairs do?" he asked. "We coordinate with local governments and civilian populations during operations," I said. He nodded slowly. "So like public relations for the military?" "Not exactly." He smiled anyway. The distance between our lives widened over time. She moved into a gated neighborhood. I moved from base housing to rental apartments near duty stations. She bought investment properties. I bought durable luggage. Dad never compared us directly. But others did. "You must be so proud of Tori," relatives would say. "I'm proud of both," he'd answer. After he died, that balance disappeared. At the will reading, Tori didn't react when she heard I was executor. She kept her face composed. When the conservation easement clause was read aloud, she leaned back slightly. "That's restrictive," she said flatly. "It's binding," the attorney corrected. The difference between those two words defined everything. Restrictive implies limitation. Binding implies obligation. Tori sees limitation as a problem to solve. I see obligation as something to fulfill. When Magnolia Resorts entered the picture, the rivalry sharpened. It wasn't just philosophical anymore. It was financial. She brought a glossy proposal packet to one of our early estate meetings. Renderings of a luxury lodge, elevated walkways, a spa overlooking the creek. It would honor the land, she insisted. By removing half of it, I replied, she accused me of being sentimental. I accused her of being impatient. Neither of us raised our voices. We didn't need to. By the time she filed the motion to remove me as executor, the quiet rivalry had become formalized in legal language. Reading her declaration in the court filing felt different than hearing her across a dinner table. Executor lacks financial sophistication. Executor's career obligations interfere with estate management. That wasn't sibling commentary. That was sworn language. I understood then that this wasn't about convincing her. It was about countering a narrative she had built carefully over years. The golden child versus the quiet officer. The market strategist versus the structured executor. As I buttoned my uniform jacket that morning, I thought about the word she used most often to describe me. Small. She never said it directly, but it lingered behind every joke about my car, every comment about my apartment, every laugh about my government salary. Small compared to her world. The uniform didn't make me bigger. It just reminded me that scale is relative. In her circles, value is measured in square footage and quarterly returns. In mine, it's measured in compliance trust and whether people can rely on you under pressure. I adjusted the collar once, checked the ribbons for alignment, and headed downstairs toward the lobby where the early morning coffee smelled stronger than it tasted. The coffee in the hotel lobby tasted burnt, but it did the job. I stood near the window with the paper cup in my hand and watched early commuters cross the street toward the courthouse. Suits, briefcases, phones already pressed to ears. No one looked like they were heading into a family dispute. They looked like they were going to work. For Daniel, this was work. For Tori, it was leverage. For me, it was compliance. At 7:30 a.m., my phone buzzed with a message from Ms. Parker, my attorney. Daniel filed a supplemental brief at 6:45. Minor additions. Nothing dramatic. I walked back upstairs, set the coffee down, and opened the court's electronic filing system. The supplemental brief focused on executor suitability. Daniel had added a short section, arguing that the role required advanced financial literacy, asset optimization experience, and proactive wealth strategy. Asset optimization. That phrase again. He cited Tori's resume. MBA. 15 years in commercial real estate development. Board memberships. Public-private partnerships. Then he listed my credentials. Captain U.S. Army. Civil Affairs Officer. Deployment history. He didn't criticize the military directly. That would have looked disrespectful. Instead, he framed it as unrelated experience. While honorable, he wrote military service does not equate to financial stewardship of a multi-million-dollar estate asset. That was careful language. He wasn't attacking my integrity. He was questioning my relevance. Ms. Parker called a few minutes later. They're leaning heavily on comparative earnings, she said, and market opportunity cost, meaning I asked. They'll argue the land's highest and best use is development. They'll say you're ignoring fiduciary duty by refusing to consider offers. Fiduciary duty is to the will, I replied. Correct. But they'll argue you're interpreting the will too narrowly, that you're prioritizing restriction over growth. That's the thing about legal arguments. They don't have to be dishonest. They just have to be persuasive. Daniel wasn't claiming I had stolen money or misfiled documents. He was claiming I lacked vision. Vision sounds good in a courtroom, Ms. Parker continued. He also suggested your duty schedule might prevent adequate estate oversight. My duty schedule doesn't interfere, I said. I know. We've documented your availability and compliance. She paused briefly. You're going to hear them emphasize lifestyle differences. I've heard it before, I figured. After we hung up, I looked at the binder again. Tori's declaration included a paragraph that stood out. Executor has limited exposure to complex financial instruments and large-scale asset management structures. Limited exposure. It sounded clinical, detached, as if I were a case study. In reality, I've managed multi-million-dollar reconstruction budgets overseas, coordinated infrastructure funding with local councils, balanced operational needs with civilian impact. But those line items don't show up on personal tax returns. Civil affairs work doesn't translate neatly into stock portfolios. Daniel's strategy was smart. He understood judges don't like emotional disputes. So he stripped the emotion out of it. He positioned Tori as the pragmatic steward of value. He positioned me as the inflexible enforcer of sentiment. He would argue that Dad signed the easement in a moment of declining health and limited foresight, that economic realities had shifted, that revisiting the restriction was responsible governance. He would not use the word greed. He would use the word growth. I buttoned my jacket and checked the time. In a federal courtroom, removal of an executor requires proof of unsuitability. Unsuitability can be based on conflict of interest, incapacity, misconduct, or inability to fulfill duties. I had no misconduct, no incapacity, so they aimed at ability. Ability is subjective. Income comparisons were their anchor. Tori earned more than I did. Substantially more. Her financial statements showed diversified investments, property holdings, corporate equity. My leave and earnings statement showed steady government pay. On paper, it looked like disparity. In practice, executor competence is about organization documentation and adherence to directives. Daniel's brief included a line that almost made me smile. Executor's minimalist lifestyle reflects limited engagement with sophisticated financial environments. Minimalist lifestyle. That's one way to describe renting an apartment near base because you might PCS in 2 years. I wasn't embarrassed by it. but I understood the optics. In a room full of polished attorneys and financial exhibits, they would contrast that lifestyle with Tori's portfolio. The implication would hang in the air. Who looks more capable? At 8:15 a.m., I stepped outside and walked toward the courthouse. The air was cool, the sky clear. Tori and Daniel stood near the entrance, speaking with another attorney I didn't recognize. She wore a tailored navy suit. Daniel's charcoal suit fit perfectly. They noticed me before I reached the steps. Tori's eyes moved over my uniform again. Slower this time. Daniel offered a thin smile. "Morning, Captain." "Morning." Tori tilted her head slightly. "Still going with that?" "Yes." She glanced toward the courthouse doors. "You understand this isn't personal." "It's filed in federal court," I said. "It's personal." She exhaled softly as if I were being difficult. "We're trying to prevent long-term financial damage," she said. "That's not an attack. It is when you question my competence," Daniel interjected smoothly. "It's not about competence. It's about comparative expertise. Different words, same meaning." I looked at both of them for a moment. "You're not arguing the easement is invalid," I said. "You're arguing I shouldn't be the one enforcing it." Daniel nodded slightly. "We're arguing the estate deserves the strongest possible management." "Strongest." The word hung there. Tori folded her arms. "You don't have to take this as an insult." "I don't," I replied. She seemed surprised by that. "You're walking into a courtroom where numbers matter," she said. "Track records matter." "They do," I agreed. Daniel checked his watch. "We should head in." As they turned toward the entrance, I noticed something in Tori's expression. It wasn't anger. It wasn't mockery. It was certainty. She believed the argument was solid. She believed the judge would see what she saw. Income charts, business acumen, market potential. She believed the court would prioritize expansion over restriction. Inside the courthouse lobby, the security line moved quickly. Metal detectors, ID checks, routine. We stepped into the elevator together without speaking. The silence was not awkward. It was calculated. On the 4th floor, the doors opened and we walked toward courtroom 4B. Through the narrow window in the courtroom door, I could see a few early arrivals already seated. Legal pads open. Briefcases at their feet. Daniel adjusted his tie. Tori smoothed the front of her jacket. I checked the alignment of my ribbons one last time and reached for the door handle. The courtroom door felt heavier than it looked, and for a second I saw my reflection in the narrow glass uniform's straight posture. Steady, no hesitation. We stepped inside. Courtroom 4B wasn't dramatic. No theatrical lighting. Just polished wood federal seals and rows of benches that fill quickly when money is involved. A few observers were already seated, local attorneys, 2 reporters I recognized from Atlanta business coverage, and what looked like a representative from the Land Trust. Daniel set his briefcase down at the plaintiff's table. Tori took the seat behind him. I moved to the defense table beside Ms. Parker. "You good?" she asked quietly. "Yes." She glanced at my uniform once, not critically, just observant. "They'll push the financial comparison hard. I expect that." We organized the documents without rushing. No frantic whispering. No last-minute edits. Everything had been filed. Everything had been reviewed. Across the aisle, Daniel leaned in toward Tori and murmured something. She nodded, then looked at me again. Her expression had changed since the mansion. Less mocking. More analytical. She wasn't trying to embarrass me anymore. She was trying to win. The bailiff entered first. Then the clerk. Routine movements. Papers shuffled. Microphones adjusted. At 9 a.m., the side door opened. "All rise." We stood. Judge Harold Whitmore entered without flair. Mid-60s. Direct posture. The kind of presence that doesn't need to be announced twice. He took his seat. "Be seated." The hearing began with formalities. Case number. Parties identified. Counsel of record confirmed. Daniel stood first. He moved smoothly into his argument voice, controlled, confident, without being aggressive. "Your Honor, we are requesting removal of the current executor due to demonstrable lack of financial sophistication necessary to manage a complex estate asset valued in the multi-million-dollar range. No mention of sibling tension, no mention of resentment. He framed it as risk mitigation. He presented charts showing projected revenue under Magnolia Resort's proposal. He emphasized opportunity cost. He cited fiduciary duty case law, suggesting that an executor must consider maximizing value where possible. Executor's refusal to evaluate development proposals, he said, reflects rigidity rather than stewardship. He used the word rigidity carefully. Then he referenced my career. While Captain Callahan's military service is commendable, her full-time obligations and limited exposure to high-level financial management create a practical limitation. Practical limitation. He didn't look at me when he said it. He looked at the judge. Tori watched without blinking. Daniel concluded by requesting temporary suspension of my executor authority pending further review of the easement's federal tax implications. Ms. Parker stood next. She kept her tone direct. Your Honor, executor removal requires evidence of misconduct, incapacity, or failure to fulfill duties. None exist here. She walked through the estate compliance timeline. Debts paid, filings submitted, asset inventory complete. No missed deadlines. No financial discrepancies. The will is clear, she continued. The conservation easement was executed and recorded properly. The executor's role is to implement the will, not renegotiate it. The judge listened without interruption. Ms. Parker addressed the financial disparity argument directly. Income level is not statutory grounds for removal, nor is professional background absent evidence of mismanagement. She sat down. The judge leaned back slightly and began reviewing the binder in front of him. The room went quiet. Not dramatic, just focused. He turned a page, then another. Daniel shifted slightly in his chair. Tori crossed her legs. The judge spoke. Counselor, your argument hinges largely on comparative financial experience. Yes, Your Honor. Do you allege mismanagement? No, Your Honor. Do you allege breach of fiduciary duty? No, Your Honor. Then your position is that the executor's professional background is insufficient as a matter of capacity. Yes, Your Honor. The judge nodded once and returned to the documents. He flipped to the section containing the easement filing and associated federal documentation. He read silently for several seconds. Then he paused, not abruptly, just long enough for the air to shift. He looked up from the page. Captain Callahan, he said. Yes, Your Honor. You are currently active duty United States Army. Yes, sir. Rank, Captain. He glanced back down at the document. Civil Affairs. Yes, Your Honor. He studied the service record summary included in the filing, standard disclosure information tied to federal litigation. He didn't comment immediately. Daniel remained still. Tori's posture straightened. The judge turned one more page. He looked at the ribbon listing, then back at me. Afghanistan deployment, 2014 to 2015. Yes, Your Honor. He removed his reading glasses and set them down on the bench. For a brief moment he didn't speak. Then he leaned forward slightly. This court recognizes your service to this country, Captain. The words were calm, measured, not theatrical, but they carried. He stood. It wasn't dramatic. It wasn't rushed. It was deliberate. Ma'am, he said, voice steady, on behalf of this court, we acknowledge and salute your service. No one clapped. No one moved. The silence that followed wasn't confusion. It was recalibration. Daniel's jaw tightened almost imperceptibly. Tori's hands folded in her lap, stilled completely. The judge sat back down. This court will now return to the matter at hand. He reopened the binder. Executor removal is not warranted absent statutory grounds. Comparative earnings and professional background do not constitute incapacity. He referenced the easement documentation. The conservation easement appears properly executed and recorded. Challenges to its validity would require substantive evidence beyond speculative economic projections. He looked directly at Daniel. Speculation regarding opportunity cost does not override a binding instrument. Daniel nodded stiffly. The judge continued reviewing briefly, then closed the binder. For purposes of today's hearing, the motion to remove the executor is denied. The gavel struck once, controlled. Court will proceed to schedule further review of any federal tax implications separately, if properly supported. The room began to move again. Papers gathered. Chairs shifted. The hearing had not turned into spectacle. It had not veered off into emotion. It had returned to structure. As the judge exited, the reporters in the back row exchanged quick notes. The land trust representative exhaled audibly. Across the aisle, Daniel began stacking his documents without looking up. Tori remained seated for a second longer than necessary. Then she stood. The hallway outside courtroom 4B felt narrower than it had an hour earlier. People moved around us. Attorneys heading to other hearings. Clerks carrying files. A reporter typing quickly into her phone. but the air between Tori and me stayed tight. Daniel adjusted his cufflinks as if the last 30 minutes had been a minor inconvenience. "We'll review the order once it's docketed," he said evenly. Ms. Parker shook his hand. "Of course. Professional, neutral, no raised voices. Federal court isn't a place for theatrics." Tori finally looked at me. For once, her eyes weren't scanning my sleeves. "They didn't rule on the easement itself," she said. "They ruled on the motion you filed," I replied. Her jaw tightened slightly. "This isn't over." It wasn't a threat. It was a business statement. I nodded once. "File what you need to file." Daniel stepped in smoothly. "We'll consider our options." He spoke the way attorneys do when they're recalculating in real time. The elevator doors opened, and we stepped inside together. No one spoke. The mirrored walls reflected 3 different versions of composure. On the ground floor, the doors slid open again. Tori walked ahead toward the exit without waiting. Outside, the Atlanta morning was brighter than it had been when we entered. Traffic steady. Reporters positioned casually near the courthouse steps. One of them approached Ms. Parker first. She handled it cleanly. "The court denied the motion to remove the executor," she said. "The estate remains under current administration. No commentary, no celebration." The reporter glanced at me. "Captain, any statement?" "Yes," I said. "The will stands." That was enough. Across the steps, Tori paused near the curb where Daniel's car was waiting. She spoke quietly to him, then looked back once more. Not angry, not mocking, evaluating. I walked toward my own car, parked a block away. The uniform felt heavier now, not physically, but because it had just been measured in a civilian arena. Judges don't salute uniforms. Daniel had been right about that. The judge hadn't ruled in my favor because of my service. He had ruled because the statute required it, but the acknowledgement had shifted something. It reframed the narrative. Inside that courtroom, I wasn't a minimalist lifestyle. I wasn't limited exposure. I was a federal officer with documented compliance and a binding instrument in hand. That mattered. Back at the hotel, I packed my bag slowly, folded the uniform jacket carefully. The cuffs were still slightly worn. They would always be slightly worn. I thought about the decision I made that morning when I buttoned it. I could have worn a civilian suit, a tailored navy blazer, something newer, something that might blend better into a room full of corporate attorneys. Instead, I chose the uniform. Not for optics, for alignment. The Army doesn't allow you to selectively display your record. It's either worn correctly or not worn at all. Tori sees clothing as branding. I see it as identification. There's a difference. My phone buzzed. A notification from the court's electronic system. The written order had been docketed. Motion to remove executor. Denied. Concise, clean. Ms. Parker sent a short follow-up message. Strong language in the order regarding statutory grounds. Good for record. Strong language. I opened the PDF. The judge had written that removal of an executor requires evidence of misconduct or incapacity, not comparative financial advantage. He emphasized that fiduciary duty centers on adherence to the decedent's expressed intent. Expressed intent. Dad's signature sat at the bottom of that easement. That was the intent. There was a brief knock on my hotel door. Ms. Parker stood outside holding a folder. "I figured you'd want this printed copy," she said. "Thank you." She stepped inside for a moment. "They'll regroup," she said matter-of-factly. Daniel doesn't like losing motions. I noticed. He may try to frame the tax angle more aggressively next time, but today's ruling makes it harder. She paused. "For what it's worth, wearing the uniform was the right call." I raised an eyebrow slightly. "Not because of sentiment," she clarified. "Because it's transparent. You didn't try to rebrand yourself for the room." That was exactly it. Rebranding implies insecurity. I wasn't insecure about my record. After she left, I sat at the small desk and opened my laptop. I logged into the estate account and reviewed the compliance checklist again. Quarterly land trust report due in 60 days. Property tax documentation current. Boundary inspection scheduled for next month. Nothing had changed in those responsibilities. The federal motion was noise around the perimeter. I checked my unit email. Routine updates. Training schedules. No escalation from the clearance office. Professional life intact. Tori's world operates on momentum. Deals move quickly. Delays cost money. My world operates on procedure. Slow, structured, documented. The friction between those worlds had finally surfaced in a courtroom. I zipped my bag closed and carried it downstairs. At checkout, the clerk glanced at my uniform and smiled politely. "Have a good day, ma'am." "Thank you." Outside, the air had warmed. I loaded my bag into the trunk and paused for a moment before getting in. Tori had expected embarrassment. Daniel had expected an easy comparative argument. Neither happened, but neither had anything dramatic. No shouting, no collapse. Just a denial order and a reminder that statutes matter more than style. As I started the engine, my phone buzzed again. A text from Tori. "Call me when you can." Short, direct. I stared at it for a second before setting the phone down on the passenger seat. The engine idled steadily. I pulled into traffic and headed north, merging into the flow without signaling anything beyond the standard turn. The traffic thinned as I crossed back into North Carolina, and I finally picked up the phone. "I figured you'd call," Tori said. "I'm driving. I won't keep you long." There was no anger in her voice, just calculation. "You know this isn't finished," she said. "Daniel thinks the tax angle still has room. He can file whatever he wants," I replied. "You don't sound concerned." "I'm not." A short pause. "You embarrassed me in there," she said. I didn't say anything. "That's the problem." I almost laughed at that. Silence has always bothered her more than criticism. "You made it look like I was attacking a war veteran," she continued. "You filed the motion. You wore the uniform. I wear it to court when I'm required to. You weren't required." That part was true. Active duty officers can appear in civilian attire for personal legal matters. I chose not to. "I wasn't hiding it," I said. She exhaled through her nose. "Do you know what that judge standing did to the room?" He acknowledged service. He shifted sympathy. "Federal judges don't run on sympathy. They run on record. But perception matters in every arena, even federal ones." "That wasn't strategy," I said. "It may not have been yours," she replied. We both knew Daniel had miscalculated something. Not the law, the atmosphere. She ended the call without raising her voice. I drove the rest of the way back to Fort Liberty in steady silence. By the time I reached my apartment, it was early evening. The building looked the same as always. Brick exterior. Modest parking lot, no iron gates, no fountain. I carried my bag upstairs and hung the uniform jacket carefully in the closet. The cuffs were still slightly worn. I changed into jeans and a plain t-shirt, then opened my laptop again. The court order had already circulated through a few local legal news feeds. Nothing dramatic. Just a summary. U.S. District Court denies motion to remove executor in conservation easement dispute. 2 paragraphs down a brief mention, Judge Whitmore acknowledged the executor's active duty military service during proceedings. That was it. No headlines, no viral moment. Just documentation. My phone buzzed again, this time an email from Magnolia Resorts' corporate office, addressed to Tori, copied to me as executor. Subject development proposal. Status update. I opened it. They were requesting clarification on the estate's position following the court's denial. Polite language. Business tone. Translation. Are we still on track or not? Tori had likely forwarded it intentionally. She wanted pressure visible. I drafted a short reply. Per federal court order, executor authority remains unchanged. The conservation easement is binding. Development proposals inconsistent with recorded restrictions cannot be considered. Direct, neutral, legally precise. I hit send. Minutes later, my phone rang again. This time it was Daniel. "I assume that response was yours," he said. "Yes, you understand the land trust agreement could still be reviewed for compliance with IRS valuation standards. If you believe it's defective, file a motion. You're very confident." "I'm consistent." He didn't respond immediately. "You're not maximizing value," he said finally. "I'm executing a will." "You're hiding behind it." "I'm enforcing it." A slight shift in his tone. "You think the judge standing today settles the perception issue?" "I don't care about perception." "That's naive." "Maybe." He let out a controlled breath. "There's still an opportunity to negotiate," he said. "Partial development, structured carve-outs, something that respects the easement but unlocks value." "That's not what the document says." "You're inflexible." "Yes." Silence again. "You're going to cost your sister a significant opportunity," he added. She made the offer before the estate closed. She anticipated resolution. She assumed control. He didn't argue that point. After we hung up, I leaned back in the chair and stared at the ceiling for a moment. In Tori's world, persistence is strength. If the door doesn't open, you find another angle. In mine, if the order is clear, you follow it. There's comfort in that clarity. Later that evening, I drove to the base gym and ran 5 miles on the treadmill. Not out of stress, out of routine. Discipline doesn't adjust itself to civilian litigation. When I got home, there was a new message waiting from the Land Trust. Appreciate your continued compliance with easement terms. Please confirm boundary inspection date next month. No drama there either. Just follow through. I confirmed the inspection date. Then I opened the estate account ledger and reviewed transactions again. Every payment documented. Every expense categorized. If Daniel came back with a tax valuation argument, he would need numbers. Solid ones. The appraisal filed with the IRS had been conducted by a certified appraiser with conservation expertise. It included comparable sales and discounted value for development restrictions. It wasn't sloppy. That's what frustrated them most. The paperwork was tight. Tori's strategy relied on flexibility, reinterpretation, market shifts. Dad's strategy relied on permanence, perpetual. That word in the easement mattered more than any projected revenue. I closed the laptop and checked my phone one last time before setting it on the nightstand. No new filings, no emergency motions, just quiet. The kind of quiet Tori once called avoidance. I turned off the light and let the room settle. The land remained untouched. The order remained entered, and somewhere in Atlanta I knew Tori was already recalculating. 3 days later, the written order hit the public docket in full. Not a summary. The complete text. Daniel called first. You've probably read it by now, he said. I have. The judge's language was precise. He didn't just deny the motion. He clarified it. Removal of an executor requires evidence of misconduct, incapacity, or clear breach of fiduciary duty. Comparative financial status is not a statutory standard. That sentence alone closed a door Daniel had hoped to keep cracked. He also added something else. The court declines to reinterpret a duly recorded conservation easement absent compelling evidence of procedural defect. Procedural defect. That was the only remaining path. You understand this doesn't prevent further review, Daniel said. I understand it sets the standard. He exhaled slowly. You've made this harder than it needed to be. I didn't file the motion. He didn't argue that. After the call ended, I received an email from the land trust attorney. Strong order. Judge emphasized binding intent. That helps. That helps. In development disputes, clarity is leverage. Later that afternoon, Tori showed up at my apartment. No text, no warning. I opened the door surprised, but not startled. She wasn't dressed for a meeting. No blazer, no heels, just jeans and a loose sweater. It made her look younger, less armored. Can I come in? She asked. I stepped aside. She walked in slowly, glancing around at the small living room. Couch, coffee table, bookshelf with a few framed photos from deployment ceremonies and family gatherings. This is where you live, she said. Yes. She nodded once like she was confirming something for herself. I read the order, she said. So did I. She sat down on the edge of the couch. I didn't expect him to stand, she admitted. It wasn't part of the ruling. No, she said quietly. It wasn't. She looked at the bookshelf, at the framed photo of Dad in his marine dress blues. You know what bothered me most? She asked. I waited. He didn't stand because you're my sister, she said. He stood because of you. There was no sarcasm in her voice. He acknowledged service, I replied. He shifted the room. I didn't argue. Perception matters, even if it doesn't decide motions. She leaned back slightly. I built my entire career on projecting competence, she said. Walking into rooms where people underestimate you and proving them wrong. I know. And then you walk into federal court looking like you don't care about appearances. I care about accuracy. She let out a small breath that could have been a laugh. You've always done that. You refuse to play the game. I play the rules. She shook her head slightly. You think those are the same thing. In federal court they are. Silence settled between us. Not hostile, not warm, just unfiltered. You could have taken the money, she said. I know. $75,000 isn't nothing. It wasn't the amount. She glanced at the bookshelf again. You really think Dad cared more about trees than financial security? He cared about permanence. She looked at me carefully. You never asked him to reconsider. He wasn't unsure. He was old. He was deliberate. That word again. Deliberate. She leaned forward, elbows on her knees. You don't understand what it's like to carry investor expectations, she said. To promise returns. To build something and then watch it stall. I understand obligations, I said. They just look different. She studied my face for a moment. You're not angry. No. You're not gloating? No. That's infuriating. I almost smiled. That's consistent. She stood up and walked toward the bookshelf. Her fingers traced the edge of the frame holding Dad's marine photo. "He would have liked the way that judge handled it," she said quietly. "He would have liked the order." She nodded slowly. "You know what Daniel said after she asked?" "What?" "He said you weaponized the uniform." "I didn't." "I know." That was new. For the first time, she wasn't questioning my motives. She was acknowledging them. "You really believe you're protecting something bigger than profit?" she said. "Yes, and you're willing to absorb the fallout, if there is fallout." She turned to face me fully. "There will be," she said. "Magnolia isn't going to walk away quietly. Then they'll need a procedural defect." She held my gaze for a second longer than usual. "You're not going to bend." "No." She nodded once. "Then I need to decide if I keep pushing." "That's your choice." She looked around the apartment again. "Not judging. Observing." "You don't live like someone who needs to win," she said. "I live like someone who needs to sleep." That earned the smallest hint of a smile. She walked toward the door. "I underestimated you," she said. "That's not new." She paused at the threshold. "You think this is about the land," she said. "It's not." "What is it about?" She hesitated just long enough to make the question real. "It's about control," she said finally. I didn't respond immediately. Control looks different depending on your world. For her, control meant directing outcomes. For me, it meant maintaining integrity within boundaries. She opened the door. "I'm not promising anything," she said. "But I'm not filing anything today." "That's noted." She stepped out into the hallway. I closed the door quietly behind her. The apartment felt smaller after she left, but not suffocating. Just quiet. On the table, my phone buzzed with a new notification from the court's electronic system. No new filings, just routine docket updates. I set the phone down and walked to the window. Outside the parking lot, lights flickered on as the sun dipped lower. The land in North Georgia was still untouched, the easement still binding. And for the first time since Dad's will was read aloud, the argument wasn't about money in that moment. It was about who gets to define value. The next week, the boundary inspection took place under a clear Georgia sky. I met the land trust representative at the gravel entrance just after 9 a.m. Clipboard, survey map, practical shoes. No media, no lawyers. Just procedure. We walked the perimeter. Markers checked signage confirmed that no clearing had taken place along the creek line. Everything matched the recorded easement conditions. "Looks good," he said. "No violations." "That's the goal." He smiled faintly. "You'd be surprised how often that's not the case." I wouldn't be. People test limits when money is involved. After he left, I stayed on the property a while longer. The air was still. Leaves shifting lightly overhead. No construction equipment, no survey flags marking future foundations. 200 acres exactly as Dad intended. My phone rang around noon. It was Daniel. "We've advised Magnolia to suspend further action," he said. "Based on cost-benefit analysis." That sounded like him. "They're not pursuing additional filings. Not at this time. Not at this time." It wasn't surrender. It was recalibration. "You made your point," he added. I followed the document. "Yes," he said quietly. "You did." He ended the call without argument. I stood there for a moment, letting that settle. This wasn't a dramatic collapse of a corporate empire. No public scandal. No courtroom fireworks beyond what had already happened. Just a strategic withdrawal. Later that afternoon, Tori called. "I told Magnolia we were done," she said. "For now," I asked. "For this property." That distinction mattered. She sounded tired but not defeated. "They weren't happy," she admitted. "But they understand risk. Risk exists." She exhaled softly. "You really weren't going to bend." "No, I know." We let that sit between us. "I've been thinking about something," she said. "That's usually productive." She ignored the dry tone. "I built my reputation on turning land into profit," she continued. "It's what I do. When I saw that acreage, I saw potential, and Dad saw protection." "Yes." A pause. "I thought you were being stubborn," she said. "Rigid, emotional." "I was being compliant." She laughed quietly at that. "Only you would frame it that way." "It's accurate." She shifted her tone slightly. When the judge stood, she said it wasn't about sympathy. It was about record. "Yes, and I've been misreading you for years." "That's possible." "I thought your silence meant you didn't care." "It means I don't escalate." Another pause. "You didn't try to humiliate me?" she said. "You could have." "I didn't need to." "That's what makes it worse." I didn't respond. She continued. "I went back and reread Dad's letter attached to the will. The letter had been short, 2 pages, clear. He wrote that the land was the one thing he never wanted leveraged," she said. He underlined leveraged. "Yes, I used that word in my proposal." I noticed. Silence again. "I'm not apologizing for being ambitious," she said finally. "I wouldn't expect you to." but I am acknowledging that I pushed this too far. That's your call. She took a breath. I'm going to step back from the estate filings, she said. No more motions, no more challenges. That was more definitive than Daniel's phrasing. Understood, I replied. I still disagree with you, she added. That's allowed, but I'm not going to litigate it. That was the real shift. Not agreement. Acceptance. We hung up without ceremony. That evening, I drove back to North Carolina and stopped at a small hardware store near base. I bought a weather-resistant plaque and had it engraved. Nothing elaborate. Just Callahan Conservation Land. Protected in perpetuity. The next weekend, I drove back to the property and mounted the plaque near the original wooden sign Dad carved years ago. No ribbon cutting, no announcement, just a visible marker that the decision was settled. At my next unit briefing, nothing had changed. Training schedules, deployment rotations, budget discussions. Professional life moved forward. No one at work treated me differently because a judge stood in a courtroom. That wasn't how the Army works. Respect is documented long before it's acknowledged publicly. A week later, a small article ran in a local Atlanta business journal. Federal court upholds conservation easement in Callahan estate dispute. 2 paragraphs about development halted. 1 sentence about military service acknowledged during proceedings. That was it. No viral headlines, no trending clips. Just record. Tori sent me the link without commentary. I replied with a simple noted. We met once more at the property about a month later. No lawyers, no investors. She walked the creek line quietly. It's quieter than I remember, she said. It hasn't changed. That's the point, isn't it? Yes. She looked at the plaque near the entrance. You actually engraved something. I prefer clarity. She shook her head with a faint smile. You win? This wasn't about winning. It feels like it. It's about enforcement. She studied the trees for a long moment. You really don't care about the money. I care about the document. She laughed lightly. That might be the most frustrating thing about you. I've been told. As the sun dipped lower, casting long shadows across the clearing, she turned toward her car. You know, she said if Dad were here, he'd probably say we're both stubborn. He'd be right. She nodded once. I'm not going to pretend I agree with everything you do, she said. But I respect that you don't bend. That's enough. She drove away without another word. I stayed behind for a few minutes longer, listening to the wind move through the trees. No construction noise. No survey stakes, no negotiation, just land preserved exactly as written. Family revenge stories usually end with someone destroyed. This one ended with something intact. The land stayed protected. The easement stayed binding, and the uniform hanging in my closet back in North Carolina still fit exactly the same way it did before anyone laughed at it. The truth is, nothing about that courtroom changed who I was. My sister laughed at my worn-out suit because she saw fabric. The judge stood because he saw record. Neither moment defined me. The paperwork did. The signature on that easement did. The choice to follow it through did. Family drama has a way of turning everything into pride and ego. But most family revenge stories aren't about destroying someone. They're about standing still when pressure tries to move you. In federal court, money talks loudly. Discipline doesn't. It just stays consistent. I didn't protect that land to prove a point. I protected it because it was written down, signed, and meant to last. And sometimes the strongest move in any family revenge story isn't winning an argument. It's refusing to rewrite what was already clear. If this story meant something to you, if you've ever been underestimated, judged by appearances, or pressured by your own family, subscribe to the channel. We tell real military and family revenge stories that focus on discipline, accountability, and quiet strength. There's a difference between loud success and earned respect. If that difference matters to you, you're in the right place.